Welcome to Versus Trump, the podcast where we talk about how the Trump administration is breaking the law and what people are doing about it. For this near live episode, I'm still Jason Harrow, one of your hosts, and Charlie Gerstein, how are you?
I'm good. We're about to talk about the most important thing we have ever talked about on this entire show.
That's right, and we're going to do it with Isha Anand as well. Isha, how are you?
Hi guys, doing well. I'm excited about this quick turnaround episode.
That's right. And I say near live because we're going to talk about the ever-changing story involving Stormy Daniels' lawsuit against President Trump, and that keeps generating news seemingly each day and each hour. So we're now recording this around 11 a.m. Pacific time on Wednesday. Thanks to the wonderful producers we use at We Edit Podcast. Quick shout out. We're going to turn this around super quickly and try and have it posted at the regular time on Thursday morning. And regular listeners, we had a little technical snafu last week with the posting of the episode. We had some audio difficulties. We're hoping to work everything out. And like I said, the folks at We Edit Podcast are doing a great job helping us out with that. Okay, so without much delay, the usual precursors, takecareblog.com/podcast is where you can find us online, and we'll have show notes and links to the complaint and other materials in this dark and stormy episode. Also, thank you. Also on Twitter at Versus Trump Pod, Versus Trump Podcast at gmail.com. Okay, so we're doing it live, as Bill O'Reilly once said. And here's where we are now, like we said, slightly past 11 a.m. Pacific time on Wednesday. So Stormy Daniels is a pornographic actress, I guess is the legal terminology. And she claims to have had an affair in 2006 and 2007 with now president, then private citizen, Donald J. Trump. This came to light in January of this year. It was broken by the Wall Street Journal. And what this lawsuit is about that's been making a lot of news is that apparently there were rumblings that it would come to light much sooner, that is in October 2016, after the famous Access Hollywood video. But she claims that she was paid $130,000 for her silence. Okay, so how does that possibly give rise to a lawsuit, and how is she suing him? So luckily, we've got lots of procedural experts here in the person of Isha Anand and Charlie Gerstein, the people of those. But just to describe a little more on the facts of the complaint. So this is a complaint that was filed in Los Angeles Superior Court in early March, and she gives a little more details herself about what she claims occurred. So she claims that in 2006 and 2007, she had meetings, intimate meetings. She actually doesn't describe in detail what occurred in her legal complaint, but she implies that it was sexual, including a, quote, meeting in a bungalow at the Beverly Hills Hotel in 2007. Very swanky meeting place in the Los Angeles area near Beverly Hills. So this allegedly occurred in 2006, 2007. As we're recording, there is now some additional news because it's unknown if this was kind of validated at the time, and this is not necessarily in the complaint. But there is some news that she apparently shared some details of this over the phone, as well as with the radio host Bubba the Love Sponge, who this is now his second major lawsuit involving a sex scandal. He was also somehow involved in the Hulk Hogan case as a friend of Hogan's. But Bubba the Love Sponge now claims that Stormy, at the time of her appearance on his radio show, actually told him that she had this affair in 2006, 2007 with Donald Trump. So there may be additional corroboration. But those are the underlying facts. So Isha, though, how does this get into court in Los Angeles Superior Court, state court, with Stormy suing the president?
That is a great question, Jason. So this is a little bit convoluted. So to kind of step back, this contract that's kind of signed, the parties to which are Stormy Daniels. They all sort of go by noms de plume or sort of anonymized nicknames, but the parties are Stormy Daniels, Michael Cohen through a sort of sham LLC, as we now know, and then Trump himself, whose kind of nickname for purposes of the contract is David Dennison. This contract has kind of two features that have sort of made headlines recently in the wake of the Me Too movement as being kind of standard provisions and contracts that are trying to kind of make something not go public. So the first is what's called a non-disclosure agreement that basically says, you don't get to talk about this. Once you take our money, you are quiet. And the contract purports to allow $1 million in damages per violation of that provision. The second thing it's got is something called an arbitration agreement. And this is something that basically says, if there's any disagreement about this contract, we don't go to court like 12 Angry Men or To Kill a Mockingbird. Like, this doesn't happen in a public forum. We resolve this dispute in what's called an arbitration, which is basically a private proceeding. So none of this stuff has to be made public by what's called an arbitrator, who has to be licensed in various ways, but doesn't have to be kind of an Article III judge who's nominated by the president or the governor or runs for election. So those are kind of the two key features of the contract. And what happens is, well before this lawsuit is filed, Michael Cohen apparently goes to an arbitrator and says, get a restraining order forbidding Stormy Daniels from talking. I get the sense she's about to talk.
So, Isha, just to interrupt you to make the timeline very clear for people. And since we're doing this live, I want to make sure this is clear. 2006, 2007 is when the affair occurs. We don't know if it continued after that, but it likely didn't, or there's no allegation that it did. October 2016 is when the Access Hollywood tape comes out. There's many women that say that they were abused or had affairs. Stormy Daniels apparently is going to do it, but she signs this contract that, Isha, as you said, has these two key provisions, arbitration and non-disclosure. And this is October 2016, and she's paid $130,000 for her silence. And in fact, nothing happens in October 2016. I didn't say that explicitly, but we didn't know this before the election. Okay, but the agreement now has surfaced because the Wall Street Journal broke the news in January of 2018 that this occurred. So now they're fighting about the contract. Sorry, Isha, I just wanted to make the timeline really clear.
No, that's great. That's super helpful in terms of timeline. So we have this TRO from temporary restraining order from the arbitrator. And then Stormy Daniels kind of goes into court herself and seeks what's called declaratory judgment, which we'll talk a little bit more about. But for purposes, for right now, that's basically the court to interpret the contract and say what it actually means. And so there's two issues raised by the lawsuit and then two meta issues that we're going to talk about. So the two issues raised by the lawsuit. The first one is Donald Trump didn't actually sign this contract. And so Stormy Daniels is saying, well, everyone's got to sign the contract for it to be a valid contract. And Jason, I want you to talk a little bit more about this in a second. But basically, the gist that you sort of learn in first-year contracts in law school is you learn, a contract doesn't necessarily have to be signed. If both parties act like there's a contract, the contract basically exists. So there's an argument to say that she took the money and therefore, that's enough to say that she agrees the contract is valid. But many states, including California, have something called a statute of frauds, which requires signatures in certain settings. So that's issue number one. She says, even if you don't buy that, right, even if you don't buy that the contract is void just because Trump didn't sign it, it's what's called unconscionable. And unconscionable basically means there are certain kinds of things you just can't contract to because they're so ludicrously unfair. And so we don't know precisely what she's getting at with this, but it's possible that she's talking about the fact that there's $1 million penalty for every time she talks about this case. It's not clear whether it's every time she talks about it or every new fact she reveals or what. So those are kind of the two issues in the lawsuit. And then after that, we're going to talk kind of the meta issues I referenced. One is this notion of declaratory judgment, like what exactly is she asking for? Is she asking for in court? And two is, how does this all fit into the arbitration? That is there a way that she can be in court even though she signed this agreement saying that any dispute will be arbitrated? So those are kind of the four things that we're going to talk about related to this lawsuit. And then we'll go even bigger picture and talk about, whether this violates campaign finance laws and what Trump is doing to try to prevent this from airing in various places and what the role of Michael Cohen and his mysterious LLC are in this whole thing. So that's a lot to cover. So let's get started. So Jason, I kind of want to hear you talk first about this kind of signature issue because you did a little bit of a deep dive on this question.
Sure. So what Stormy wants is to get out of the contract primarily because David Dennison, that is the real Donald Trump, didn't sign it. Now, let's just talk first about what she gets if she wins. What she gets if she wins is the freedom to talk about the events described in the contract, which is the affair that she allegedly had with Donald Trump, without fear of penalty, other than other legal violations, right? So you're always in danger of being sued for defamation, that is slander or libel, if you say knowing lies about a public figure with malicious intent. But she claims that she has text messages or photos or some other kind of physical material.
Donald
She also
Trump
claims she has Yeah, but perhaps I didn't say that. We don't know. But there is the contract has both allegations of physical material and intangible confidential information. And what she wants, if she wins, is to be able to share that without this automatic penalty that is breaching this hush agreement, this non-disclosure agreement. And her best argument, or what she claims is her best argument, is that there was never an agreement because Donald Trump didn't sign. And she attached the contract, and the contract indeed has lots of blanks where David Dennison or Donald Trump was supposed to sign, and they are unsigned. And the other side, Michael Cohen and President Trump and Sarah Huckabee Sanders, have never said that they have another version of the contract where Donald Trump signed. Now, bracket, if they did say that, that would sort of give even more credence in some ways to what she's saying. So I'm not sure they would actually want to make that argument. But nonetheless, they've attached a version of the contract without these signatures. So the contract is governed by California law, and the case is in LA Superior Court, which is the main state trial court in Los Angeles. And it's kind of a first-year contract question, but a tricky one, of whether or not there is a valid contract if one party didn't sign. I think it will be a close call, but Isha, I think that they still had a contract. And there's a couple of reasons. One is, in California, you can still have oral contracts, right? And the question is, was there a meeting of the minds? And there's pretty good evidence that there was a meeting of the minds because Stormy herself signed it, her attorneys signed it, Michael Cohen signed it, and there was a payment made, and she was actually did not say anything in October of 2016. So that's pretty good evidence that at least at the time, she thought there was a contract. There's also another doctrine called an implied in fact contract, which is related, which says that by the party's actions, you can imply that there's a contract, even if the written instrument isn't necessarily perfect. And again, we have about a year and a half of conduct, including a payment, the acceptance of the payment, the cashing of the check, presumably, and Stormy's silence that indicates that she and the Trump people and Michael Cohen thought there was a contract. So I think that's a pretty good argument. There is some California law that says that if the evidence shows that the signatures of all the parties were required as one of the conditions of the completed agreement, it is incomplete and not necessarily binding upon those who sign until all the others sign. So the question that I think a court will look at is this a special contract that said explicitly for all the provisions, you really need to sign here, even more than just the regular agreement, which of course always has signature blocks and always said this agreement is not valid until signed. I think that will be tough to prove. Again, the law often doesn't like to let people get out of contracts when they've already gone really far down the road. Right? It would be one thing if nothing had happened and she said, whoa, we were still negotiating. There's a reason this was unsigned. But this is now a year and a half later, and she appears to just want to reconsider the bargain that she genuinely already made. So that's my impression. The key thing, and Charlie, I don't know if you've got a different idea about whether the arbitration condition is valid, right? Because one thing about arbitration is that there's at least some law that those types of conditions, which give up your right to appear in a regular court, need to be really explicitly agreed to. And so even if the payment and the general provisions about staying hush for the payments are valid because she accepted the payment and the courts might not want to let her get out of the bargain, all these details of the contract, including the ability to force her into arbitration and not let her be in state or federal court, that may be trickier for Trump to make sure that's part of the agreement. I don't know. What do you think?
Yeah, so I wonder whether the rule of California law that you were talking about covers contracts that don't say anything about signature and just happen to be signed by one party, or contracts that do say this agreement is effective only upon signing the contract. Because there was the case about circumstances in which it says like, this agreement is effective when received by the other party or something, and that didn't happen. And that was found to just be convenience or formality rather than an actual condition. And then other contracts that said this is effective only if signed. And this contract said this is effective only if signed. But so like assuming then that we're in the world of implied agreements, I think that's right about arbitration, and it also might be right about the liquidated damages provision. So this contract says it's $1 million penalty for each violation. There'll be questions about what is and isn't a violation. But if that weren't the case, I think it would not be difficult for Stormy Daniels to find support, say, online to help her defend against violating this contract, right? If it were just actual damages, she could just say, all right, I'll take my chances. But each violation being $1 million, depending on how they interpret this, plus the fact that it's an obvious willful breach, we might be talking about significant sum of money. That might be within the, you needed to sign this to get the specific thing.
So that will transition really nicely to our second point, Charlie. But before we leave the signature issue, I want to just flag two things that may wind up making a difference in the analysis. The first one is, as Jason so cogently explained, there is this notion of oral contracts, contracts created by conduct, but almost every state has something called a statute of frauds. And that essentially says certain kinds of things, we're not going to accept an oral contract or contract by conduct. So the classic example is like real estate. That thing has got to be in writing, and a lot of states also require a signature. So in California, the statute of frauds says that stuff has to be in writing, has to be signed by both parties. And one of the categories of contracts that fall under the California statute of frauds is something where an agreement by its terms is not to be performed within a year from the making of the agreement. This is credit to Slate for finding this provision. And so there's an argument at least to be made that a non-disclosure agreement, which by its terms is not to be performed within a year, that is, it's supposed to go on indefinitely, may or may not fall under this provision. We'll direct you to the Slate article for kind of more detail about why that may not pan out, but we wanted to add that as one overlay. And then the second thing we just want to say is, as Jason and Charlie alluded to, this arbitration provision doesn't necessarily rise or fall with the rest of the contract. And at a high level, it's somewhat unclear whether a court will be more or less likely to uphold that provision as compared to the rest of the contract. On the one hand, there's this notion that arbitration is giving up a lot of rights. It's not the kind of thing that you sort of do lightly. But on the other hand, there's something called the Federal Arbitration Act. And a lot of case law over the past 20 years of corporations basically going to court over and over again to say the Federal Arbitration Act says you've got to allow people to arbitrate. And ordinary state law defenses are what's called preempted. So basically, if there's a state law provision that singles out arbitration for special treatment, the Federal Arbitration Act says you can't do that. So just wanted to flag those two kind of more rabbit-holey issues. But to move on to the second point, Charlie ended by talking about liquidated damages, which is liquidated damages basically means rather than proving in court, I was harmed in XYZ way, pay me for that harm, the contract specifies how much you pay. And in this case, it's $1 million per breach. So I wanted to ask you guys, Stormy's kind of second argument is, okay, even if you find this contract valid without the signature, it's invalid as what's called unconscionable. That is, this is a ludicrous contract. Courts should not be in the business of upholding something so unfair, essentially. And she doesn't say exactly what part she thinks is ludicrous, but I'm guessing the $1 million liquidated damages piece is some part of it. So what do you guys think? Do you think that this will wind up being found unconscionable in some way?
So I can't speculate on whether I'm the only person on this podcast who is not barred in California and doesn't know anything about California law, so I don't really know how that would work out. But I do want to briefly raise that there's been a lot of discussion about this in the context of sort of hush agreements and settlement agreements for people who allege sexual abuse rather than just, by all accounts, the interaction between Stormy Daniels and Donald Trump was consensual on both sides. And, we might think it tawdry, but there's nothing other than adultery wrong with it. I think the more sort of frightening circumstance is that we allow people to pay large sums of money to have others keep quiet about their years of sexual abuse. And there has been some talk about changing the law around those kinds of agreements to call them either unconscionable or it's essentially a version of reverse extortion, where we would call it extortion if there weren't, legal process involved. If it weren't in a settlement agreement, we would say it's extortion to say, I'll report you for having committed a crime if you don't pay me money. It's odd because we don't generally think about that party as the one who's doing something wrong here, but the law does generally invalidate those contracts, and there's some talk about doing the same in this context. That kind of intuition is at work here as well. Like, letting people do this, it causes some problems, right? Like, it keeps secrets that oughtn't to be kept secret. This person's the president. California courts might not like that. Jason, what do you think?
Yeah, I think that's right. I mean, under existing law, as far as I can tell, the unconscionability argument, it's not even really developed in the complaint. I'm not even sure, as you said, Isha, what she's saying is unconscionable. And to the extent that what she's saying is unconscionable is the $1 million per breach, well, okay, a court can find that part of it unconscionable and perhaps not enforce it, but the agreement could still be valid. You are right that this could be a moment for revisiting this entire department category of hush agreements, which exist in all kinds of areas. We've known for a long time that celebrities and prominent people do them, sometimes for, perhaps even valid reasons, right? Things that they are accused of that they believe they didn't do, or there's even evidence they didn't do, with people or acting in bad faith, it may well be easier to just pay money to not allow that person to say something. And that could be advantageous for everyone involved. So the line will be tricky. Whether Stormy Daniels ends up creating a historic precedent about unconscionability of hush agreements, we shall see. That's the exciting part, again, about litigation in the Trump world.
Yeah.
After 2017, right? That's what this show is about. Maybe the Stormy Daniels case will be the most consequential case that there is because of this issue.
Yeah, I mean, and as we said, this 1-2 punch, the non-disclosure agreement, which says you took money in exchange for not talking, and we will fine you like crazy if you do talk, plus arbitration. If you have any issues with this contract, you can't go to court. You got to go to this sort of private body that there's a lot of empirical evidence is often biased in favor of large corporations, because large corporations are the ones that sort of use these arbitrators more often. That 1-2 punch is really common. So, okay, speaking of creating a precedent, Charlie, do you mind just like explaining to our listeners kind of the first meta question I talked about, which is, what does it mean that she's looking for a declaration or declaratory judgment here?
Yes, absolutely. And I'll try to do that very quickly because I had some questions from friends and listeners about this over the week. So the declaratory, each state has one, and there's a federal declaratory judgment act or a declaratory judgment procedure. And these things came about in response to problems sort of just like this, which is there are two parties with a legal relationship, and one of them wants to do something, and that person would become a defendant in a lawsuit if she did it. But she wants to avoid being a defendant in a lawsuit and just get a declaration of her legal rights. So rather than just go forward and breach an agreement that she thinks is an agreement, but there's some uncertainty about that, she can go into court and say, okay, I want you to tell me whether or not I can do what I'm planning to do. So it essentially is a device by which a would-be defendant can turn herself into a plaintiff in a lawsuit so that she can start a lawsuit and get into court. And it used to be that courts would refuse to entertain things like this and would say, well, go ahead and do it and you can find out. And obviously we don't want that world because nobody would do it. So this is like a classic use of the declaratory judgment. Makes perfect sense. She wants a judgment from a court saying, you can do this, and if you do it, you will not breach whatever agreement would lead to $1 million of liquidated damages against you.
Exactly. But let's now move on to the bigger stakes here, because the fascinating thing about this case is, although the posture of this is classic declaratory judgment, I have a contract, it may be invalid, I want to know, court, if it's invalid before this person sues me. She has, in fact, already done it. The allegations are, or the news reports range widely, that she has already given an interview to Anderson Cooper, and also, by filing this very lawsuit, making the claims she has made and not filing it what's called under seal, which means to the rest of the world confidentially, she has already breach the agreement. That seems undisputed, right? So even though the posture of the case is, can I judge breach the agreement? And typically if like a large company was doing this, they would be very careful not to have actually breached before they ask the courts if they can. She has already done it. So that means that this lawsuit has all these interesting legal features. It has potential huge exposure for Stormy Daniels. If she wins or loses, she could be liable for millions and millions of dollars if she loses. But the big thing that she wanted to do, which is be able to speak about the agreement, be able to tell the world that she has had an affair with Donald Trump at the Beverly Hills Hotel in 2007 and other places, she's already done. So, and she's already made clear that this $130,000 payment from Michael Cohen and this shady LLC was made. So, Isha, like, what does that mean? What can possibly happen? Can Trump, based on this agreement, shut down the 60 Minutes interview?
Oh, wait a second, Jason. You're answering that, not us. You're the one. What is Jason, who has some professional experience with these issues, can perhaps speak to what it would be like to be in the room with general counsel for, what is it, CBS? For CBS, talking about whether or not they should run this story. Like, what are some of the threats? How's this all going to go? Jason's got to answer this one. Okay, we're not speculating.
Fine. So, Isha, I'll kick you the next question. But if Charlie, you want me to answer the first question.
We have a bona fide subject matter expert.
Yeah.
It's true. And it can be a short one, because the answer is that I am sure that the folks at 60 Minutes and at CBS News are thinking very carefully about ways to minimize their legal exposure. But they, as we know from this contract, and as is completely expected, they are not a party to this agreement. They didn't promise anyone that they wouldn't disclose any of these secrets. And in fact, 60 Minutes has been for 50 years in the business of exposing secrets. Secrets that people said should have been confidential, even legally confidential, or top secret. And that's because the media, under pretty clear First Amendment law, has broad powers to run stories and air broadcasts of materials, especially that are true and non-defamatory. And even if they are defamatory, that is, even if they are knowingly false, it's extremely difficult, if not impossible, for the government, the president of the United States here, to get an injunction before they air, a so-called prior restraint that many listeners who have seen The Big Lebowski will know Walter is very against prior restraints. Those are almost impossible to get. Basically, under the Pentagon Papers case and other cases, the government will have to show a clear and present danger to the nation. There may be danger to Trump's reputation if there is anything left of his reputation, but that is not the kind of harm that can stop the president, or that will get a court to stop 60 Minutes from airing this. So, it would have been interesting if this didn't happen yet, right? And they knew about it and they could go into court and stop Stormy Daniels from talking about it. And indeed, they appear to have gone to an arbitrator and gotten an order that says, Stormy, you can't talk about it. But she apparently ignored it, blew through it, didn't care about it. Maybe didn't even know about the arbitration agreement because it doesn't have the same kind of process that a state or federal court does. And so, Charlie, I think the answer to that is pretty easy. And indeed, there are reports that although the Trump administration was thinking about trying to shut down 60 Minutes and CBS from doing this.
Not the administration, Trump and his team personally.
Yes, exactly. That the interview is apparently prepped to air on Sunday, March 18th. It was with Anderson Cooper, and they haven't sued yet. And it would now be absolutely extraordinary and extremely
But do you
unlikely.
think anyone's worried in the CBS legal team office about liability post-publication? I agree there's no chance that they're going to get enjoined from doing it, but what's the evaluation there?
Yeah, so, there's two possible theories. The first is just straight up, you are responsible for defamation. And publications are often sued when people say defamatory things in them. They're sued along with authors, investigative journalists, and people who use the airwaves here, right? It is CBS's airwaves. So they've got to do their homework and make sure that this is non-defamatory. The fact that the president is a public figure and the fact that these are issues of public interest means the standard is very high, but they're no doubt doing lots of research to make sure that they have some corroboration of Stormy's story. And indeed, she says she has some corroboration, not just the things she said to Bubba the Love Sponge, other contemporaneous statements, and maybe even text messages or pictures. Those haven't gotten out yet, but we'll have to wait for the interview. So they're no doubt thinking about that. There's another interesting theory that we've seen more recently that is more untested, which is that people who want to keep things silent, and the various organizations that are often involved in non-disclosure agreements, I imagine things like the Church of Scientology, which has been widely reported, is involved there, perhaps Harvey Weinstein, etc. I don't know specifically that they've made this claim, right? But they are often parties to non-disclosure agreements. And they may say that airing something when it is subject to a non-disclosure agreement, here, the unusual situation, even subject to an arbitration order saying don't talk about it, is facilitating the breach of a contract, right? Is inducing the breach of a contract, interfering with contractual relations. States state this tort somewhat differently. This is less well established. It seems to me here that this would be a bad case for it because I very much doubt that 60 Minutes, which is about as staid as journalistic enterprise as there is in the business of actively trying to get Stormy to break the agreement, right? No doubt that she and her lawyers want publicity. They were shopping this around. They felt like Anderson Cooper in 60 Minutes was a good venue and they could work together to tell the story. And the courts would doubtless, in light of the First Amendment interest, try and read this tort very, very, very narrowly. It would be weird if you could say it, you had a First Amendment right to say it wasn't defamatory, but the news organization could still be liable for helping people breach agreements. That said, the attitude toward the news media obviously has changed in not only the Trump administration, but the Obama administration started going after news media who received leaks and things like that in a fairly unprecedented way. So whether or not the media is responsible for actually publicizing information that should not be publicized, the typical answer has been no, but we'll see if the tide is turning at all. That's maybe a little bit of a risk. So I don't know, Isha, if you've got any thoughts on that.
That was so great, Jason. Thanks. I didn't realize that latter piece was a theory that was being floated. This is all super interesting. So I want to pivot really quickly to kind of our last outside the four corners of the lawsuit question, which was what the sort of twinned issue of like who paid what and what's the significance for campaign finance. So just to kind of lay the groundwork, there's some question about who exactly ponied up this $130,000. So Michael Cohen at some points has said it was his money. Trump didn't even know about this thing. He did it. If that's the case, as Common Cause has pointed out, that looks an awful lot like an illegal campaign contribution, right? He paid a huge sum of money to do something to basically boost the campaign, because kind of keeping Stormy Daniels from going public about this in the kind of waning days leading up to the election of 2016 was really important to Donald Trump's victory. The other story is that, there's some evidence that he kvetched at various points that Donald Trump was supposed to reimburse him. He said he just merely facilitated this for some other payer, either Donald Trump or someone else. And if that's the case, then it looks a lot like an illegal campaign expenditure, right? If Donald Trump's the one that's paying for it. Now, that said, prosecutors tried to nail John Edwards. Do you guys remember John Edwards? Kind of populist Democratic candidate before populism was a thing.
Vice presidential candidate.
Vice presidential
nominee,
right?
I should say.
Yeah, absolutely. John Edwards sort of had a similar kind of hush money to a mistress scandal. And when prosecutors tried to nail him for this, the jury wound up acquitting, basically, as far as we can tell, because they sort of thought this really wasn't a campaign expenditure. It was more of sort of a personal expenditure. The timing here is a lot different than the John Edwards timing. And it was really in like they try to, as you explained, Jason, they try to implement this kind of two-pronged hush-hush approach right as the kind of polls are tipping and right in the sort of lead up to the election. So it looks a lot more kind of campaigny. Although, as Rick Hazen has pointed out, if Trump himself pays, there's sort of like this intuition that maybe it's more personal than campaign related. So anyway, so that's the kind of campaign backdrop. But I want to, as you guys know, Charlie loves to talk about lawyers' conduct, and we often roll our eyes at the things that at Charlie's kind of high horse about legal ethics. But here, this seems like a pretty good fodder for Charlie to break down potential ethical violations here.
Yeah, and there are some easy ones. First of all, it's fine. The setting up of the LLC, which we've described variously as shady or sham on the show, is not itself a problem. It's okay to set up a corporation or corporate-like entity to, facilitate anonymous transactions. That's fine. That's what these things are often used for. No problem on its own. The problem is that Cohen, as a lawyer, as I talk about all the time in the show, has unique obligations to behave less terribly than other people. And those obligations stem in part from the fact that the law will protect his communications with Trump and the Trump organization. So what concerns me foremost at a very broad level, what concerns me most about Cohen's conduct is that it's insanely duplicitous. Mm-hmm. The statement that he personally paid, without expectation of reimbursement, $130,000 to someone who had embarrassing information about his boss is preposterous. I'm sure that Cohen's a pretty wealthy guy. He's a lawyer. He works for Donald Trump. I don't doubt that he makes a lot of money. It is implausible that he had $130,000 to spare. We later learned that he took it from a rotating home equity line on his home, which means that, he has a $130,000 debt that he needs to retire or they're going to seize his house. He's not just doing that out of his pocket. That's preposterous. He then issues this statement in response to the Common Cause complaint. So Common Cause filed a complaint with the FEC about that this might be an illegal campaign contribution. And he files this response saying, I was not reimbursed by the Trump campaign or the Trump organization. Congratulations, that leaves out one potential person who could have reimbursed you, of course, which is Donald Trump. So, okay, carefully worded lawyer statement, deliberately misleading, surely within the category of things that lawyers with our slightly higher obligation of honesty oughtn't to do intentionally, right? Only an idiot would have not recognized that he left out one potential party here. So those are two big acts of dishonesty. If he's setting this transaction up so as to avoid the problems that John Edwards went into, then he's in much bigger trouble, right? If he's actually intentionally setting this transaction up to avoid regulatory scrutiny, that's money laundering, right? That's not just a legal ethics problem, that's a criminal problem. We don't have evidence of that, but you have to scratch your head about why they did this, right? Surely Donald Trump wanted to stay anonymous, but there's lots of ways to stay anonymous without having your lawyer out of his own personal funds make the payment, right? The way this is supposed to work is Donald Trump gives his lawyer the money, it goes in a special escrow account that lawyers have to keep so they don't mix their money with their client's money. And then from the escrow account, it goes to the LLC, and from the LLC, it goes to Stormy Daniels. So far, so good. That they had it come from his home equity loan is where you start to say, why in the name of God would you do that? You could have kept it anonymous. That anonymity is easily achieved here through legal means. What else are they trying to do? As yet, we don't have questions. There is no doubt in my mind that the New York bar authorities are looking into this. They can start complaints on their own. Surely someone has filed one by now. If no one has, someone should, because this is at least questionable.
Right. And then there, relatedly, you mentioned the New York bar, but there's a kind of other kind of percolating issue, which is that it appears that Michael Cohen, who was not barred in California, did some legal representation in a California arbitration, which seems to potentially be problematic as well.
Yeah, you're probably not supposed to do that. I'm not sure what the state bar rules are on that, but yeah, in one of the quaint provincialisms of the United States is that lawyers here are not necessarily lawyers there. So
right. Well, and so maybe that brings us full circle. We talked about the kind of last meta issue related to the lawsuit.
I'm sorry, I had one more. I forgot. Okay. This actually could be the easiest one and the biggest one. So in Reed, the escrow account thing I was talking about, the easiest way to get disbarred is to commingle your funds with your client's funds.
What is commingling, Charlie?
Commingling is where it has nothing to, yes, we're talking about, there's a dumb joke to be made here about Trump and Stormy Daniels, but I'm going to let that go. This is where you take, so no lending your clients money except in very limited circumstances, and no basically putting funds that are not yours, that are either like your client has prepaid you for work you haven't done or has given you the money to hold until you pay it to Stormy Daniels, say, no holding that money that someone else has an equitable interest in your own personal bank account. The reason for this is otherwise lawyers would be borrowing against their clients' money all the time, and that would be a nightmare. So if you do that, it's like an auto disbar. So if the bar authorities find that Donald Trump had the equitable interest in that $130,000 when it was in that bank account, Cohen's in big trouble. And that's a plausible finding here, right?
Yeah.
Even if it came from his home equity loan, if that was a transaction structured so that Donald Trump could pay him back later, that's still Trump's money.
Yeah.
Right. He's basically advancing Trump the money in that case.
He's advancing Trump the money. And somehow I feel like they didn't dot all their I's on this one.
and so
it's also worth noting that Cohen's an idiot, right? Like in many other circumstances, Cohen's on the Trump payroll because he's willing to do something that no one on this show would ever do, right? Like he's what they call a fixer. He's not there because of his legal talent. He's there because of his ethical flexibility and his blind loyalty to Trump. So it is implausible that he did this correctly.
But that said, to sum up, Charlie, I mean, can you blame the guy? He's trying to do an NDA involving the future president and a porn star literally 10 days before the election, right? The date is...
Oh my God.
It's a tough job, but you know what? I didn't sign up to work for Donald Trump.
These agreements are dated October 28th, 2016. Some of the signatures are October 31st, 2016. This is literally 8 days before the election. He didn't have time to check all these rules you're talking about, Charlie.
Well, he wasn't working on the campaign.
You know, who knows? It's just being rushed. So I think that's the lesson, dear listeners, is just take your time on these hush agreements.
Just take your time.
With porn stars, I think, because there's a lot of campaign finance issues. There's a lot of potential hot water to be gotten into, ethical issues, and we'll see. So we'll see if this interview airs on Sunday. We'll see how the lawsuit goes. The last bit of breaking news on this case is that there's a hearing set for July 12th. Dear listeners, there were some funding cuts to the California court. So if you'd like to have them go more quickly, you should, if you live in California, you should have your assembly people and your state senators give more funding to the courts. But they filed this March 6th for a declaratory judgment action. They didn't necessarily ask to expedite it, but the first hearing is apparently going to be July 12th in LA Superior Court.
We should note, so to circle back on, we said that we were going to talk about the two issues in the lawsuit, which is the signature issue and the unconscionability thing. We're going to talk about the three issues outside the four corners, which is 60 Minutes, campaign finance, and legal ethics. And then we're going to talk about the two meta issues of the lawsuit, which is declaratory judgment that Charlie talked about, and then arbitration, which we touched on a little bit. But there's still this really big open question, which is this going to go forward on July 12th and stay in court? Or is the arbitrator or is the court going to say, look, you signed an arbitration provision. That means that everything, including questions about the validity of the contract, goes through arbitration. So that's a little bit tricky because the arbitration provision in the contract is structured as Trump's option. And Trump, of course, is the only person who hasn't signed the thing. So that makes it a little bit complicated. But there's a very real chance that actually what happens with this lawsuit is they say, you want to question any part of this, including the validity of the arbitration clause itself, you got to do it in arbitration, which I know sounds sort of Kafka-esque to listeners, but this happens all the time. People try to go to court to challenge contracts, including the part of a contract that says you got to go to arbitration, and the court says, go take it up in arbitration. Tell the arbitrator that it shouldn't be in arbitration. See what they say.
Yeah. It's also worth noting that what might be happening here, and this is a little bit outside our expertise, but I'll briefly touch on it, is that they might have done the 60 Minutes thing and filed this suit, which is itself a breach of the agreement, because they're calling Trump's bluff. right? They're like, you're not going to sue me to stop this. It looks bad enough for you already. And Trump has a long history of saber rattling about suing people for things and then not doing it. So he threatens to sue, all the people who accused him of sexual assault after the Access Hollywood tape came out. And as yet, he has sued none of them, although at least one has sued him.
Which means, Charlie, just to conclude here, to conclude our near live episode, after the 60 Minutes interview, we'll have to see what happens with this lawsuit, right? Because if Trump is in fact gonna just be bluffing and not actually gonna sue Stormy, it doesn't really make sense for her to be in court and litigating this. What if she gets a no answer, right?
Yeah, I'd withdraw.
So
at
she
that
may
point,
withdraw.
right?
And then Charlie will have you back on as our lawyer expert to what if we realize that this suit was filed only for the purpose of getting this agreement and some of those facts out there and not to actually win in court and then withdraw it. Is that a violation of her new lawyer's ethical duty?
It absolutely is.
Yeah, of course, because when you've got a hammer like Charlie does, everything looks like a nail.
That's right.
Lots of ethical violations. Okay, so that's for Charlie, your spinoff, lawyers acting badly. But for now, that's the end of our Stormy Daniels episode. No Trump nuggets this week. I've got some other stuff to say, and I was planning on doing it, but I think we should just keep it right there. Focus on that case. Listeners, we also last week promised some actual in-depth analysis of the more perhaps legally substantive but less salacious lawsuits that the Department of Justice filed against California, claiming that 3 state laws related to immigration enforcement or not assisting the federal government with immigration enforcement are preempted. We will definitely get into those and lots of other legal developments in the future. But until then, listeners, see you next time. See you, Charlie and Nisha.
Thanks,
Adios.
Jason.
The red light of the train